Hey everybody, it's me Hannah with SoloSuit, and in today's video I'm going to show you an interview that I had with a licensed and practicing attorney named Sarah Wolk. In our interview, Sarah and I talk about frequently asked questions that we get at SoloSuit, like how does the debt collection lawsuit process work? How can I settle my debt? How can I prepare for my court date? And what happens during arbitration? So if you've been sued for debt recently, I think that this video will help you find some answers to your questions and get you started on the path to not only responding to your lawsuit and debt collectors in general, but on the path to resolving your debt for good and moving on with your life. Thanks so much for watching, and without further ado, here is my interview with attorney Sarah Wolk. All right, I think we're good to go. All right, thank you so much, Sarah, for joining our YouTube channel today to go over a few questions that a lot of our customers and consumers in general have about how to answer a debt collection lawsuit and resolve it. We really appreciate you taking the time to answer these questions and, give people answers and maybe a little bit of hope during the process. Before we get started, I just wanted to give you some time to introduce yourself. Could you tell us a little bit about what you do and the firm that you work at?
Yeah, my pleasure. And thank you so much for having me too. So yes, I'm Sarah Wolk. I'm the managing partner at a law firm called Wolk & Levine, which is in the Los Angeles area. We help with a lot of different civil matters. A lot of it is business-based, which a lot of times is also contract-based and does involve debt sometimes. So we handle civil litigation as well, and debt lawsuits are a form of civil litigation. So we help out with things that are relevant to, I believe, the consumers that SoloSuit works with.
Yeah, definitely. And can you tell us a little bit more also about how you partner with SoloSuit currently?
Sure, yeah. So the SoloSuit consumers contact SoloSuit and start the process with them of the drafting of an answer, which is the response to a lawsuit. And my firm at that point steps in and helps make sure that the answer complies with certain rules and is going to be accepted as a filing in court, or hopefully will be accepted as a filing in court. And we also do a consultation with SoloSuit consumers so that they have any basic questions kind of about the litigation process or the answer itself, we're there to answer those.
Perfect. So you help any customers at SoloSuit who are in California, whose case is in California, right? And you just have short consultations with them when they've purchased our service and answer their questions and maybe continue to point them in the right direction and either representing themselves or finding a lawyer to take on their case, right?
That's correct. Yes, we do only work with California consumers because we're licensed in California. And if you're in a different state, you need an attorney from that state. And we do work separately with SoloSuit consumers sometimes if they want help in addition to what SoloSuit is offering them. We can be hired separately for certain things like different kinds of motions, for example.
Awesome. And that actually brings up a good point. Before we get into the nitty-gritty of these questions, I just wanted to say that even though Sarah is an attorney, she does not represent anyone watching this video, and this doesn't necessarily constitute as legal advice, but just legal information that you could potentially apply to your case if you're watching with those questions, right?
Thank you very much. I'm going to speak generally to try and provide helpful information, but there's a lot of exceptions and nuances to things. So nothing that I'm saying is ever a guarantee or definite and doesn't necessarily apply to everyone or to the particular person watching this video right now.
Okay, awesome. Well, Sarah, thank you so much again for being here today. Let's go ahead and jump into some questions. These are some questions that I got together that we receive a lot from people who have either found SoloSuit on the internet and have more questions about how to respond to debt collectors. We also hold a weekly webinar on our YouTube channel, and we hold live Q&A sessions there. And so these are some questions that we get frequently that I think it's hard always to give a concrete answer to some of these questions, but we wanted to pick your brain, Sarah, and see what you thought about some of these. So I'll just jump right into them. The first question is, what is the typical process of a debt lawsuit? What does that look like?
Okay, so a debt lawsuit is going to be similar to other civil lawsuits. If you've been involved in one of those, the general process is going to be very similar, most likely. Basically, you're going to have at least two parties. You're going to have a plaintiff and a defendant. The plaintiff is the party that initiates the lawsuit, files it, and is suing the defendant. In the case of a debt lawsuit, that's usually going to be a debtor and a creditor. So the creditor is the plaintiff, the person that is owed something, usually money, and the debtor is the party or the person that owes the money to the creditor. So to start the lawsuit, the plaintiff or creditor files a complaint and a summons. Once that's filed with the court, they get it back stamped, so it's an official document, then it's public record. And then they have to actually serve it on the debtor. If it's not served, the debtor has no obligation. It's still a lawsuit, but the debtor doesn't actually have to respond or do anything. There can't be a judgment that's issued. There are also requirements for how the summons and complaint have to be served. Generally speaking, that's going to be personal service, meaning it's given to the actual defendant. So if you're being served, you want to kind of make sure that you're properly served, because if you're not, again, you don't have an obligation to actually respond or do anything. However, once you are served, that is what triggers the time for you to respond to the lawsuit. Now, there's different kinds of responses, but if you fail to respond, the other side, the plaintiff, is going to most likely request a default against you. If a default is entered, you can no longer participate in the case. So basically, the court isn't going to listen to anything you have to say anymore. This generally means that it's going to be easier for the creditor to actually get a judgment against you. They still have to present evidence to the court to show their case, but there's going to be no one able to argue against it because you can't participate. So generally speaking, cases when there's a default are going to go to a judgment. So you want to try and respond if possible, and a response can come in different forms. An answer is a very common way to respond to a complaint in a lawsuit, but there are different motions, like a motion to compel arbitration, that you can file as well. So you can consider different things. So then you kind of get to the middle of a case, and in the middle of the case, there's going to be sort of two different things going on. One is basically things that involve the court, and the other is things that don't involve the court. Things that involve the court are going to be things like hearings. There's almost always a hearing called a case management conference or trial setting conference. This is basically a status conference where the judge is going to want to find out what's going on with the case, kind of how the case is proceeding, when it's going to be ready for trial. If the judge doesn't think it's far enough along, that hearing could be continued. If the judge thinks it's a good time to set trial, then you'll get a trial date at that hearing. So that's something to look out for, because generally speaking, the date of that hearing is going to be in the initial paperwork that you're served with. So with the summons and complaint, you're going to get a service packet, or you should get a service packet. And there's going to be a lot of information in there, and it's probably overwhelming, but you really want to read through it because it's going to give you most likely this court date and a lot of other information, things that you have to do before the court date, which include like meeting and conferring, talking to the other side, filing a case management statement. So you want to read through all of that. In addition to that basic hearing and other similar ones like status conferences, there can be motion hearings. And that's basically when there's a dispute between the parties that can't be resolved without court intervention. So then you go to the judge and ask for assistance. Now, the other side of that is the things that don't involve the court. So there's a lot of things that happen in a case that are kind of informal. You don't actually go to the courtroom. You're just talking to the other side, talking to the other attorney. And the main thing that's going to happen in most cases is called discovery. And discovery is basically when you're finding out what the other side has, how they're going to make their case, and how they're going to present it. You can also talk to the other side about settlement informally. And you can also talk to other parties like witnesses, possible witnesses, to try and find out what information they have and maybe help support your case. So those are going to be things that are going to kind of happen during the middle of the case. Now, I mentioned settlement already. You can talk about settlement at any point in a case. You can settle informally, but the court also usually encourages settlement, and in doing so, they will set some sort of mandatory settlement conference frequently, and sometimes encourage the parties to do some sort of other mediation. Now, the parties always have, and when I say parties, I mean the people involved in the lawsuit, the companies involved in the lawsuit, the plaintiff and the defendant. So if the court sets a settlement conference, you're going to attend the settlement conference. You have no obligation to settle, but you have to participate in good faith, basically. You can also go to private mediation. Private mediation can be good because the mediators generally spend a little bit more time on the case, but it also costs money. You pay the mediator to do this, whereas the court settlement conferences are free. And then if the case does not settle, then at some point you get to trial. And trial can be before a judge or a judge and a jury. And what you do to prepare for that is going to differ between the two. So you want to make sure you know if you're going before just a judge or a judge and a jury. And you also want to make sure that you, again, read all the paperwork you get from the court, whether it's at the beginning of the case or at one of the hearings with the judge, because a lot of times the courtroom itself will have some specific rules that you have to follow for things that you file with the court before trial. And when I say file things with the court, I mean you actually submit them to the court so they become an official record and the judge actually sees them at that point. So I think that covers the general process. Any other questions about that?
No, I don't think that I have any other questions, but just to give a little recap, there's a lot of different routes that a debt lawsuit can take, but typically I think like the most common routes would be, the plaintiff or the debt collector or creditor, they file the summons and complaint. And then if you don't respond in time, you either lose automatically by default, or if you do respond in time, the case could move forward, whether it's going into some sort of a case trial setting where you have to show up and you might, meet with the plaintiff face to face and have to settle face to face, right? Or it could move into discovery, which is where you said like you kind of are gathering your documentation and your evidence to try to present your case to the court, right? But there's lots of different, I guess, routes that a debt collection case can take. We actually have a flow chart SoloSuit that details it. I'll show it on the video right now, but it kind of just goes over a bunch of different routes that your case could potentially take. But it really just depends on the specifics of your case and the factors of your debt. Were you going to say something though, Sarah?
Yeah, I was going to clarify a couple things if it's okay. One is that if you have a default entered against you, you don't automatically lose. It's just generally you're going to lose and you can't actually do anything to prevent the other side from getting a judgment. But the other side still has to actually present things to court. So it's not literally automatic. I just want to clarify that. And then settlement and discovery can be happening at the same time in a case as well. They're not really like separate things that happen. And the timing of them, like discovery pretty much starts right after, sometimes very soon after a party is served. And settlement usually is a little bit later on, but discovery is usually still going on.
Gotcha. Thank you for those clarifications. I think the main takeaway though from everything you just said is like the best thing to do when you have been sued for debt in most cases is to file a response, because if you don't do anything, you do risk that default judgment, which makes it harder for you to defend yourself. So I think that's like that first step is to file an answer. And at SoloSuit, we can help people create an answer that's customized to their case and just get that filed in. And then they can decide where to go from there, whether it's hiring an attorney or trying to settle the debt, right? But yeah, thank you for those clarifications. Let's move on to the next question. So you touched a little bit on discovery. I don't know if you could give us like a specific example of maybe a recent case you've taken on, like what happens in discovery. Maybe give us, like I said, specific examples of real life cases. You obviously don't have to tell us anyone's names, but yeah, can you tell us a little bit more about what that looks like?
Yeah. Do you want me to also go over the different types of discovery?
Whatever you think is best. Maybe like keep it fairly succinct, but whatever you think would be helpful for just a regular consumer to know.
Okay. So discovery, generally speaking, is information gathering. It's your opportunity to find out what information the other side has, whether it's what witnesses they're going to call, what documents they have to support their case. And they can also ask you for those things as well. So there's different things you can do here. You can send actual written requests for different things, whether it's information or documents. You can also take a deposition, which means that you're in person actually asking questions of someone. And this allows you to ask kind of follow-up questions on the spot, which is nice sometimes since it can be difficult with written questions to get thorough information. And then there's also subpoenas, which are requests to third parties. That means that a company or a person who's not actually involved in the lawsuit might have information that would support your case or the other side's case. And you can actually send a subpoena to them for them to give you those documents or provide deposition testimony to give you information. Now, there are concerns with discovery, like you asked for examples. So a lot of times there's discovery disputes. This is where a lot of motions come up. So for example, one side might serve discovery questions, written discovery questions, and the other side, let's say the defendant responds to them. But the plaintiff who served the questions is not happy with the responses. They feel that the responses are incomplete for some reason. So then they would contact the defendant and say, hey, I think you need to provide more information here. This is why. And then the defendant can provide more information or say, I don't think I should have to. And if they have a dispute at that point, then plaintiff most likely would file a motion to compel further responses with the court, and the judge would then take a position, make a ruling on whether further responses are required. So that's something that comes up quite a bit. So that's kind of a good example of something that happened in the discovery phase that shouldn't be that surprising. You don't want to have a motion filed because it's additional time and effort, but it happens. You can also get sanctioned, meaning fined, if you handle discovery improperly with no good reason. So you do want to try to informally resolve disputes involving discovery with the other side. One other thing to keep in mind is in limited civil cases, meaning cases under a certain amount of money, which recently increased to $35,000, but can change. There's a limit on how many discovery requests you can send. If you're in the unlimited jurisdiction, meaning over that amount, then you don't have any limits. So that's something to keep in mind if you're in a limited jurisdiction case as well. So that's kind of the important things that I think are noteworthy, but I'm happy to talk about any of them in more detail or other things too.
Yeah, I guess as a follow-up question, can you think of any recent cases you've dealt with? I know you've probably heard of LVNV funding, Midland Credit Management. Can you think of any cases maybe with those big debt collection names where the case has gone to discovery and how it was handled from there? I don't know if you have any recent cases you've dealt with where that happened.
Recently, I had a client, Susie, who, and I changed her name just because I don't want to reveal any confidential information, and she owed the plaintiff a debt, and the plaintiff served special interrogatories on her and requested just tons of financial information. Now, Susie didn't want to provide the financial information, but because the lawsuit involves a debt, some of it was actually relevant to the case. And so she is required to provide some of her financial information to the other side. However, there are certain things like tax information, tax returns and stuff that are privileged, and you don't have to provide that to the other side. So we did actually have a dispute about that because the other side wanted the information, and we said you're not entitled to all of that. And we actually had to go to court and have the judge help us resolve it. And then, they kind of got some information they wanted, and they wanted a little bit more. So they then noticed Susie's deposition, so they could talk to her in person and try to kind of get a little bit more information without actually asking for privileged information. And that's kind of how they got around some of the limitations and what's allowed in discovery.
Cool. Thank you for the example. I think it's kind of hard to hear all the time, the exact court process of how it works without hearing a real life story. So thank you for showing us what discovery might look like in a debt case like this. Let's move on to the next question. I'm going to go to this question that we get a lot actually at SoloSuit. And it is, when you get sued and you have a hearing or a trial, what actually happens in court? What is the physical process when you show up at the courthouse? What actually happens?
Yeah, so this is definitely something that our clients even worry about when we're going and they just want to go and observe. Court can be kind of a scary place, but something to remember is that everyone there is a person. The judges are people. So although you want to be very respectful and polite and formal in some ways, you also need to remember that you're going to just have a conversation with the judge is essentially what's going to happen. So from step one, you get to the courthouse, you go to the courtroom. If you don't know what courtroom you're in, you want to look at the paperwork in your case, and it should be on the first page of a lot of the documents. It's going to say the judge's name, and usually either the department or courtroom division. Sometimes, depending on the county, those courtrooms are called different things, county and even city sometimes. So you get there, and then you want to check in. The judge, ideally you get there before the hearing starts. And so the judge is not actually in the courtroom yet. There's going to be a docket somewhere most likely, and the docket is a list of the cases that are being heard that day. And you want to find your case on that list. It's going to have a number associated with it, meaning generally the number in which the court is going to call the cases. So number one is going to be called first by the judge. Number two is going to be called first, but the judge can go out of order as well. So you check in by saying who you are, defendant, your name. So defendant, Sarah Wolk, and then your case number two. Defendant, Sarah Wolk, case number two. And the clerk of the court is usually going to be the one checking people in. Once you're checked in, then you just wait. You wait for the judge to actually take the bench. Once the judge takes the bench, the judge is in control of the courtroom. So you should not be talking. You should be listening to what the judge says, listening to the judge's instructions. When your case is called, then you go up to the table that's close to the judge's actual bench. You can also appear remotely a lot of times these days. So if you're remote, then you don't actually have to go anywhere. The next thing is to introduce yourself to the judge. So you're gonna again say your party and name, and so defendant Sarah Wolk, for example. The other side, the plaintiff, is usually going to go first, and then you go second. From there, the judge is pretty much going to lead the way. So the judge might ask each side for certain information, and if the judge asks you for information, you want to try and respond. You want to address the judge by your honor. That's the polite and formal way to address the judge in your case. And you want to also remember to speak up. If there's something that happens or something that happens or something you don't understand, it's okay to ask questions. You just want to wait for your turn. You don't want to interrupt other people or talk over other people. So once the case has kind of gone through whatever process it's going to, each side argues or the judge asks the questions, the judge will give some sort of ruling. Even if it's not a motion hearing, there is a ruling. So this could be the setting of a trial date. That would be considered a ruling. So you want to make sure you hear what the judge says, the information the judge actually confirms in the case. And from there, the judge might order someone to actually give notice of that ruling, meaning sending a written document to the other people in the case of what happened. And then your case is over. Usually you want to say, "Thank you, Your Honor," and leave.
Okay, so just a little recap. I was taking notes while you were talking. So you get to the courthouse, you go to the courtroom that should be listed on your court documents that you received. You check in, and then you wait for the judge to come in. He or she might be in charge of several other cases that day as well. When they call your case, you approach the judge's bench, I think is what it's called. You approach the bench, right? And then the judge will lead a conversation between you and the debt collector or the creditor that's suing you or their attorneys. And during that conversation, don't be afraid to speak up and ask questions. Don't interrupt anyone, and be sure to address the judge as Your Honor. And then lastly, the judge will give a ruling, whether that's scheduling another trial or maybe making a firm decision in the case and entering a judgment. Is that right?
Yes, that's a great summary.
Okay, awesome. So I guess with that in mind then, what do you think are some good ways that someone who might be representing themselves in court could prepare for their court date?
So one thing that I think is the best advice I was ever given as a new attorney was know the facts. If you know the facts of the case, you know what's going on, you can almost always have a meaningful discussion with the judge. You're not an attorney. The judge knows that. Assuming you're not an attorney, the judge knows that. That doesn't mean you can get away with whatever you want, but the judge isn't going to expect you to have the same level of legal knowledge as an attorney. But if you understand, you filed this document, on the other side filed this document, and the complaint says this. The complaint says, this contract existed, I did this, I borrowed this money, I didn't pay this money back, and you know that information, then you can follow along with a lot of what's going on, and you can also answer questions. And that goes a really, really long way. And that's what you can do as someone who's not an attorney. You can know the facts of the case and know what's going on. So that's the number one thing I would say to do. I would also make sure you do read all of the documents that the court gives you, because there is additional information in there about what is going to happen at certain hearings or trial and things that need to be filed beforehand as well. So certain hearings actually do require you to file something, even if the court set them. So for example, a case management conference, sometimes also called a trial sitting conference, depending on what county you're in, is basically like a status conference, and the judge is going to want to get information. But you also have to file something submitting some information to the court beforehand. So the judge has an opportunity to kind of read this information if they want to, and be a little bit more prepared for maybe what questions they want to follow up on with you at trial. So if there are documents that are required, you want to make sure you file those. You can actually be fined if you don't follow court rules. So that's something else to remember. From there, if you are going to something where there are going to be witnesses or evidence presented, then you also want to make sure you prepare your questions to ask witnesses and know what documents you're going to actually enter into evidence. But that's generally going to be just a trial. There's some exceptions to that, but For the initial hearings, you don't need to do that kind of preparation.
Can you tell us a little bit about the difference between a hearing versus a trial in California, how that works?
Yeah, so a trial is going to give you an actual final outcome of a case. Of course, you can appeal that, but it's the end of the trial court. Then a hearing is going to be something prior to trial. So this is going to mostly be things like status conferences and motion hearings. So the judge is going to be involved in kind of making sure that the case moves along. And that's the main purpose of things like status conferences or case management conferences. They want to make sure that the parties aren't just sitting back doing nothing, wasting the court's time. They also will help with motion hearings. That's also a hearing and not a trial. There will be an actual outcome, like a ruling on a motion where a motion is granted or denied. And that sounds kind of like a really big deal. And it can be, but it's also not a final outcome of a case. There can be a party that loses 5 motions in a case and then wins a trial anyways. Obviously, if you can do well on motions, you get more of what you want during the case, which might increase your chance of winning at trial, but it doesn't mean that you won't win at trial. So that's the biggest thing, is trial is really the end of the case, and everything else before that is just kind of leading up to trial, even if there are certain decisions made in those hearings.
Okay, so at trial, though, that's where you might have the judge lead a conversation between you and the plaintiff in trying to either come to an agreement or just hearing both sides and then making a ruling based on what they heard, right?
Sort of. I mean, that's where the parties actually have to present their case. So the judge is going to lead the way less at trial. In the hearings, the judge will actually kind of lead the way on what they want. But at trial, the plaintiff has an obligation to actually present evidence. So they have to say, I'm calling Hannah as my first witness, and then ask you questions. The attorney for the plaintiff actually has to ask you questions. The judge can ask questions too, but they don't have an obligation to do so. And if the plaintiff is unable to present evidence to support their case, they lose. So trial does require a lot more preparation. It's going to be more formal, and it is difficult a lot of times for consumers to handle trial on their own, but it's not impossible. And you want to have all of your evidence there with you, witnesses and documents and everything, and be prepared to actually go over it in front of the judge and also sometimes jury.
So it sounds like the trial is maybe more your stereotypical, what you think of when you hear of a trial in a movie, where the judge is there with the jury and you're calling up witnesses and asking them questions and just trying to prove your point or prove your case, your side of the case, right?
Yeah, exactly. Like all the TV shows that we watch, they go to trial on like day 2. The thing that they show in the courtroom is almost always the trial. Now, you're going to wait a lot longer for your trial than that. It's very unrealistic to go to trial that quickly, but that's what to expect, where there's a witness sitting next to the judge and then the attorney is walking around asking questions. Now, the attorney's not going to be walking around. That's also a little bit unrealistic most of the time, but that's what's going to happen, where there's actual question asking by the attorney or the defendant, and not as much the judge. The judge is going to be ruling on things like objections, but not questioning witnesses.
Okay, gotcha. And would you say that like most debt collectors or creditors want to avoid going all the way to trial? Like maybe if you reach out to them before the trial date to try to come up with a settlement agreement, are they trying to avoid going to trial as well? Because it costs money, it takes up resources and time. So I don't know, it would make sense to me that they would rather just settle before the trial date. Would you agree?
Yeah, I agree. Generally speaking, plaintiffs and defendants want to settle because there is risk in going to trial for everyone. You have a good case, it doesn't matter. You can still lose. You probably won't, but you can. You never know what is going to happen. So settlement is generally speaking a good idea. Now, you can't force anyone to settle. So sometimes if the other side is not being reasonable, not willing to settle for something that makes any sense, then it's not worthwhile. But a lot of times, if you talk to the other side and you're willing to be reasonable, they will be too. But you're probably not going to get away without paying or doing something. Both sides have to compromise usually for a settlement to work. But when they do, they usually end up happier than if they go to trial. And you're not going to think that's true, because in the moment, you're not going to want to give up. You're going to want to fight. But I have so many clients who decide they're going to fight and then come trial, and they're like, oh my gosh, this is so expensive. This is taking so much time. I don't even know what's going to happen. And they wish they had settled. So it's really generally a good idea.
I think that pretty much answers all my questions about like trials versus hearings, but that is a question that we get a lot because I think a lot of people are really anxious about how to prepare for their court date. But it sounds to me like you can prepare by just gathering all of your evidence, gathering your documentation, knowing the facts about your debt and your case. And then, you know, if you have the opportunity, try to settle before your court date, because a lot of collectors may be willing to do that and they probably want to avoid the court date as well. Let's jump over to the next question. So I wanted to pick your mind a little bit about arbitration. You mentioned that you may file a motion to compel arbitration, which basically, according to my understanding, would move the case out of a court setting into a private arbitration setting. Can you tell us a little bit about how that can be effective for credit card debt cases and what the arbitration process looks like?
Yeah, so when you are served with a lawsuit, if you are interested in filing a motion to compel arbitration, meaning forcing the other side to arbitrate your case, you want to consider it right away. So you'd file it instead of filing an answer. So you need a basis though. You can't just force someone to go to arbitration for no reason. And usually that's going to be in a contract. So a lot of contracts actually require arbitration. Some allow arbitration. So if you have that option, then you want to consider whether it is a good idea for you. One of the things that people think is that arbitration is less expensive than going to court. And that is almost always false. You actually have to pay an arbitrator to handle the case. You pay them an hourly fee. You're not paying the judge an hourly fee. There are court filing fees and everything, but generally those are not going to add up to be nearly as much as paying an arbitrator. However, the fact that it is costly is also sometimes a reason why you want to file it, because the other side is going to be paying as well. And so a lot of times if the debt isn't worth a lot compared to how much the creditor would be paying to arbitrate the case, they don't want to go to arbitration. It's not worth it for them. So if you file a motion to compel arbitration and they think it's going to be successful, or it is successful, meaning it's granted by the judge, then they would have to go to arbitration to pursue the case. And we have had multiple clients where they do that and the other side drops the case. So it can be a very, very smart tactical move. That being said, it can be risky because you might have to split the fees with them. And if you're successful and the plaintiff continues to arbitration, which they can do, then you're on the hook for fees also. So, you know, it's kind of a personal call there. Something else about the process of arbitration, it's very similar to the court process. However, you don't have the option for a jury. So if you're someone who, if you go to trial, you want to be before a jury and not just one person who's similar to a judge, then you might not want arbitration. I don't really think that's a reason to not go to arbitration if that's the only thing you're considering, but it's definitely something to consider. So those are the main things. And like I said, the process is very similar to a lawsuit where you'll have an opportunity for discovery, information gathering from the other side, and the other side will also be able to ask you for information. The arbitrator usually will encourage settlement. That will frequently happen more with the arbitrator instead of going to another party like you would in a court case though. And then you'll go to an arbitration, which is the word for the trial in arbitration, basically. You're still going to be questioning witnesses and submitting documents. Some arbitrators treat things a little less formally and participate more than a judge will, because the judges have to follow pretty strict rules. And the arbitrators have some more leeway for rules and how they handle things. But the general process is going to be the same.
I love that. So arbitration can be a really good move if maybe you have a debt that's not super big and you want to try to leverage it to get the other party to just dismiss the case, because it could end up being more expensive to go to arbitration than the debt is even worth, right?
Exactly.
So maybe it's a smarter move if you don't owe like a ton of money. So I guess, could you give us like a range of how much might make sense? Like if you're being sued for $1,000 or less, maybe it would make sense to do arbitration, or do you have an amount in mind?
Yeah, I mean, I would think that if your debt is probably even $20,000 or less, the other side is probably not going to want to pay for arbitration. Now, your contract also might say who pays or how arbitration is paid for. Frequently, it's split. So you would pay half and the other side would pay half. And in that case, I think, $20,000 or maybe even $30,000 of debt would not be worth going to arbitration. But if the contract says, you pay for the arbitration fees. Obviously, you want to know that that's the case and the other side wouldn't care. But there are situations also where the plaintiff might have to pay for all the fees. And that, again, would be even more money for them and very little risk for you. And all those situations would kind of change, the amount. But I think probably if the debt is $20,000 to $30,000 or less, there's a good chance the other side won't want to deal with arbitration. And at a minimum, will be willing to settle for a pretty small amount. Of course, there's no guarantees.
Yeah, we actually had recently, I interviewed a SoloSuit customer who was being sued, I think in South Carolina, and it was Discover Credit Card. So big credit card company was coming after him, and he filed an answer, and then they filed a motion, and in response to their motion, he filed a motion to compel arbitration, which is another service that we offer at SoloSuit. We offer that document people can customize to their case. So he used that and he filed it into the case, and then they just dropped the case. So it must have been one of those situations where for them, it wasn't worth the cost and the time of going to arbitration to fight for this particular debt. I also think he had other defenses in his case that probably led to the dismissal. But yeah, that's really cool that that's such a good tool for people who maybe aren't being sued for big numbers that they can use to either push it out of the court process, which can be intimidating. But I also think it's interesting, like if you file a motion to arbitration, do you think that you might increase your chances of being able to come up with a settlement outside of court and arbitration altogether? Like if the arbitration has potential to be granted, do you think that the collector might say, well, then let's just get on a phone call and try to settle before any court or arbitration date? Would you say that's true too?
Yeah, no, Hannah, you're totally right. I think that is very likely. I also think even just showing the other side that you're going to do things in the case is good. So regardless of what it is, if they see that you're not going to just sit there and make it easy for them, that's also an incentive. So not only do you have in that situation their potential interest in not wanting to pay for and deal with arbitration, but also just knowing that you're going to be involved. So I think there is a good chance that they might reach out and try to settle. And honestly, if they don't, you can too. You can talk to the other side about settlement. You might want to have an attorney's help or some sort of assistance, but there's nothing stopping you from contacting the other side too.
Yeah, I think that's cool. It just feels empowering to know if you do get sued for debt, you don't necessarily have to hire an attorney. Of course, an attorney will help, but if you know the facts enough in your case and your case isn't too complicated, you also can be empowered to reach out and have that conversation on your own and settle before going to court, which is awesome. Cool. Well, let's go on to my next question, which is actually about debt settlement. A lot of people wonder, when they are, they might have several different credit card accounts and several different collectors that are coming after them all at the same time. So people in that position who may owe several different debts or big debt, what would you say is the best option between debt settlement, debt consolidation, and bankruptcy? Do you have any thoughts on any of those three options for people who are dealing with serious debt?
So there's not really one that is better for everyone. However, you described a situation where there's a lot of different debts. So I think that is probably a good situation in which you want to probably consult with a bankruptcy attorney. Usually you can get a free consultation to find out whether you would qualify. One thing to consider with bankruptcy is that even if you file, there are certain debts that are called non-dischargeable, meaning they don't go away even if you file for bankruptcy. So if you have some of those debts, it makes that less likely your best option because you're not actually getting rid of the debt and you're still going to have bankruptcy on your record. So in that situation, then debt consolidation or debt settlement are probably the better options. Now, if you can get some good settlements or you only have, maybe a few debts, then find out what you can settle those for. There's no harm in finding out what a company or a creditor is willing to accept. You don't have to say yes. And if you can't get any good amounts, contact a debt consolidation company, try to consolidate the debts and see how that goes. You can even, after a lawsuit is initiated by one creditor, there are some companies that will still consolidate your debts and they'll settle out the lawsuit for you. So you can still consider these options even after a lawsuit is filed. But some form of settlement, if you're not filing for bankruptcy, is a good idea because if you don't address them, the debts are just going to get worse. And a lot of creditors, they're not getting paid anyway. So a lot of times it's better for them to accept some sort of money, which is less than the total amount owed, than continue not getting paid. So that's their incentive to settle.
So I'm assuming, as someone who represents consumers in these cases, that you've had to negotiate settlement on behalf of your clients at times. Is that right?
Yes.
Can you tell us what settlement negotiation is kind of like? And this would be outside of the court process. So maybe you call up the opposing law firm and try to negotiate a settlement. What kind of tactics work for that, I guess? What kind of language would you use to try to negotiate the best settlement for the consumer? Or keeping in mind, like if a consumer wants to do this for themselves, like what might they say?
Yeah. So one thing that can be useful to say is if you are considering filing for bankruptcy, bring that up. Because if the other side knows that the debt might go away completely, then that's another reason why they want to accept some money instead of getting none. So you have to be a little careful because you're not supposed to say this if you're not actually considering filing for bankruptcy. But if you are, then that really incentivizes the other side to give you a good offer. Now, the party that's initiating the settlement discussions usually will make some sort of settlement offer. When it comes from the plaintiff, it's frequently called a settlement demand, even though it's really just an offer. And whoever makes that first demand or offer usually starts in a more favorable position than they are willing to accept. So the plaintiff is going to ask for more money than they want. The defendant is going to offer less money than they're willing to pay. And then you go back and forth, countering each other until you get to a point where one party decides, okay, that's a good enough offer, I'm going to just accept it. Now, at some point, the parties will stop negotiating. So you don't want to assume that the other side is going to continue countering you forever. There is a bottom line that people have, and also a certain point at which they think the negotiations are just pointless. So if you owe $500,000 in debt and you offer $10, you're probably not going to get a counter offer because that's just not a real offer. They're not really going to consider taking $10, and they don't think that you're going to offer anything that is reasonable that they'll accept. So they're not going to waste their time. So you have to kind of balance making sure you don't offer a lot more too soon than you want to pay and kind of end up in a position where you have nowhere to negotiate. Balance that with not offering so little that the other side doesn't take you seriously. But generally speaking, it's going to be one party makes an offer, the other party makes an offer, and then the first party counters, second party counters. And that'll sometimes go on a few times, and hopefully you come to a point where someone agrees to an amount and you actually settle.
So I know it probably depends on the case and all the factors that play into the case, but do you have kind of like a rule of thumb of like a good initial offer to give? Like, are we talking 20%, 30, 50? Like, what is an offer that might make sense to start negotiation?
There's some things you want to consider, like how old the debt is and how much money there is. Also, who's suing you. So one thing that I don't think we talked about yet is that there's the original party that you borrowed money from, but they might not be the party that's suing you. They can actually either sell their debt or assign their rights to the debt. And if that debt is purchased, then you might be corresponding with a party that you know nothing about, but they have rights to that money now. A lot of times, if a debt has been purchased from an original creditor, that party purchased it at a pretty low percentage. So they're going to be willing to accept a little bit less than maybe the original creditor was. So that's something to keep in mind. In terms of actual percentages, a lot of times I think that you want to start, below 50% of what you owe. I'd say if you start by offering less than about 10 to 20%, the other side is not going to take you seriously. If the debt is older, you probably have a little bit more leverage. But to actually settle a case, I'd say that a lot of times the settlements fall in the range of, on average, maybe 40 to 60% of the debt is probably the kind of middle range of where the settlements come. I guess that kind of is around 50%. So both sides kind of come to the middle. But I've seen cases that do settle for 10, 15% of what the debt is. And it's not uncommon. So if that's what you can afford, it's still worth trying.
So I guess to recap, it sounds like it depends on if you're being sued by the original creditor, so like the bank or the credit card company who lent you the money, or if you're being sued by a debt collection agency or a debt buyer, maybe the debt buyer purchased the debt portfolio and had ownership and the rights to collect on it transferred over to them. So if you're dealing with one of them, they might be willing to negotiate a lower settlement than if you're dealing with like the creditor or the bank or the credit card company, right?
Right.
But that's good to hear that, settling for 10, 20% is not unheard of. It might not be as common. You said the sweet spot is somewhere between, did you say 20 to 60%? Is that what you said?
40 to 60% is like, there's a really good chance of settlement. But I see a lot of cases. I mean, I don't see that many that settle for over that amount because generally the consumers are not going to be able to pay that much. But I see a lot of cases that do settle for 20 to 30%. So you don't want to start too high. You want to, start a little bit lower and see if the other side is willing to accept a lower amount. I mean, if you can't afford to pay more, then don't. Something else that might be noteworthy is that in your negotiations, you can also discuss payment plans. So just because you're in the situation of a lawsuit doesn't mean that's not an option. There are definitely settlements that involve payment plans. Usually it's going to have some sort of lump sum payment up front and then a number of installments after that at a set rate. So for example, if you can afford to pay $1,000 now, but you're willing to settle for $10,000 on a $50,000 debt, then you could say, I'll give you $1,000 now, and then I'll make 9 more payments of $1,000 once a month. And that sort of thing is possible as well. It doesn't have to just be a lump sum of money. So that's something else to keep in mind in your negotiations.
So that actually leads me, I think, to my last question, which is another question we receive a lot. And it is, what happens if you get sued and you don't have any money or even any assets? Like, what can you do in that circumstance?
Yeah, so you're probably going to be representing yourself because attorneys in a situation like that are going to charge an hourly rate most of the time. But there are fee waivers in most courts so that at least the filing fees with the court, when you file things, the trial documents or the case management statement or your answer, those fees can be waived. So you can request a fee waiver and that will help. And there are some services like legal aid type things that might help, but they also just provide some information online. SoloSuit's actually a really great resource as well for some of that. When it comes to something like trial, then you can kind of do some of your own research and stuff too online and try to figure out what's going on and read everything that the court sends you. That's helpful. Just try to stay as informed as possible. And, you can always consider bankruptcy, which, we kind of mentioned before. And if you can't actually represent yourself and you just don't feel like you can handle a case, then if it goes to a default judgment, there are certain exemptions and things for collections as well. So just because there's a judgment, obviously, if you can, you should pay the judgment. But if you can't, then the other side has to try to collect. They can try to garnish wages and they can try to levy bank accounts and things like that. But they're not entitled to everything you have. So even if you're in that process, there's a certain amount of money that you're entitled to keep because you're allowed to live your life and survive. So you want to keep that in mind too, even if you get to that spot in a case.
Cool. So I think that covers all the questions that I have. Is there anything else that you want to say just to consumers who might be watching? I don't know, offer them some words of encouragement or point them to any resources?
Well, I think it's really nice that there's companies like SoloSuit that are kind of an inexpensive way to help when someone doesn't have a lot of money so that you can at least try to participate. It doesn't mean you're going to win, but like I said before, even just participating makes it more difficult for the other side to actually get a judgment against you, and it gives them more work. And they're paying an attorney to actually represent them in court. So everything that you do that they have to handle or respond to costs them more money. So that's usually a good thing. And then, other than that, I think, as Hannah, you've mentioned a lot, settlement is usually a really good thing to pursue. So that's something you can start thinking of right after you're served with the complaint if you want. It's not something you have to wait for. You can do it at any point during the case. You can do it right after you're served. You can do it right before trial starts. You can do it in trial, actually, just as long as there's not a judgment.
Awesome. So you can really negotiate a settlement at any stage of the debt collection process, right? Even before a lawsuit is filed.
Yep, definitely.
Cool. Well, we actually also have a service. I'll just put a plug in for that right now too, called SoloSettle, where we help people negotiate debt settlements through a software that we use. So it's kind of like a tech-based approach to debt settlement, but it empowers consumers to represent themselves in the case, to have that conversation on their own, and to negotiate those terms until they come to an agreement and avoid having to go to court, which, let's be honest, I don't think anyone wakes up in the morning thinking, I really am excited about my court date today. I think most people would rather avoid that. So yeah. Well, thank you so much, Sarah. I really appreciate the time you took to explain some of these processes. I think you gave a lot of really good answers to these common questions. So thank you so much.
Yeah, my pleasure.
I really hope that this video was useful, and if you've been sued for debt, I hope you know you're not alone. SoloSuit is rooting for you, and that is why we share conversations like the one I just had with Sarah. It's to help individuals know how to resolve disputes and resolve debts. So if you have any other questions or you want more information, please reach out to us at support@solosuit.com or check out our website. As always, thanks so much for watching and good luck with resolving your case.